When an arrest happens, you need post-arrest bail immediately. Speed is everything. Right. Every minute in pretrial detention feels like an absolute lifetime. Under Section 497 of Pakistan's Criminal Procedure Code, you need a precise strategy because the legal arguments made right now dictate your client's entire future. Exactly. It is the difference between months in prison or fighting from home. So let us dive into this fast-track guide on securing post-arrest bail. Can we get bail? That is the panicked question every family asks first.
It is the most urgent question any criminal defense advocate will ever face.
But the answer is not simple. It depends entirely on the specific charge.
Precisely. The law dictates exactly how we must answer that frightened family.
You are either looking at guaranteed freedom or a massive uphill legal battle.
We have to instantly decode the statutory law to manage their expectations properly.
Understanding the specific provisions of the CrPC is absolutely non-negotiable here.
The quality of the legal argument is what ultimately decides their liberty.
Here is our roadmap for this explainer. We start with the post-arrest crisis. Then we examine the strict Section 497 prohibition against granting bail. Next, we will cover the crucial statutory exceptions to that strict rule. After that, we look at weighing the specific bail factors in court. Then we map out the exact procedural pathway through the judicial system. Finally, we will highlight the dangerous pitfalls of bail cancellation.
Section 1. The post-arrest crisis. Let us start with classifying the offense.
Amir, this classification is the absolute first step when an arrest takes place.
Step 1 is checking the 5th schedule of the Criminal Procedure Code.
We must immediately determine the legal nature of the alleged offense.
If it is a bailable offense under Section 496, release is guaranteed.
The law explicitly says the accused shall be released in those cases.
It is an absolute right. The court has zero discretion to refuse it.
But non-bailable offenses under Section 497 change the entire legal landscape.
That is where the really intense legal fight actually happens in court.
Because if it is non-bailable, the accused does not just walk out free.
The court has to actively decide if they deserve pretrial release.
Which means we must rigorously convince the judge using statutory arguments.
Discretionary bail requires a highly strategic approach to secure that release.
Even in that discretionary zone, we rely on one massive constitutional principle.
Bail, not jail. This is foundational to our criminal justice system.
It comes straight from Article 9 of the Constitution regarding security of person.
The Supreme Court affirmed this in the Tark Basra case.
That ruling established that pretrial detention is the exception, not the rule.
Because an unconvicted person is legally presumed completely innocent before trial.
So the burden is entirely on the prosecution to justify keeping them locked up.
Exactly. It is never the accused's job to prove why they should be freed.
The state must provide compelling, specific, factual reasons to deny liberty.
Holding someone in jail significantly impairs their constitutional right to a fair trial.
They cannot consult lawyers or gather evidence properly from a prison cell.
Which is why the courts strongly lean toward liberty before a final verdict.
Amr. Section 2. The Section 497 prohibition. This is the ultimate bail roadblock. This is where securing pretrial freedom becomes incredibly difficult for the defense.
The biggest obstacle is the strict prohibition found in Section 497, subsection 1. The law says bail shall not be granted under certain severe conditions.
Specifically, if there are reasonable grounds for believing the accused is guilty.
And that applies to offenses punishable with death or life imprisonment.
In a capital or life sentence case, the door to bail aggressively shuts.
It makes our job as defense advocates significantly harder right from the start.
Unless we can prove to the judge those reasonable grounds do not actually exist.
We have to relentlessly attack the prosecution's evidence right out of the gate.
If the court sees valid reasonable grounds, they must legally refuse bail.
That creates a very high evidentiary bar for the defense to clear initially.
You have to dismantle their primary accusations during the very first hearing.
It is a high bar, but what exactly constitutes reasonable grounds?
The Mohammed Bashir case from 2018 clarifies that legal standard perfectly.
The Supreme Court explicitly said a mere allegation in the FIR is not enough.
The judge is not running a full comprehensive trial at this early stage.
They are simply making a quick, tentative assessment of the initial evidence.
There must be objective evidence beyond the complainant's bare statement.
The accusation needs actual, tangible support to block a bail application.
So the prosecution needs actual corroborating forensic or medical evidence.
What if it is just one highly interested witness with prior enmity?
Then the court might rightfully rule the grounds are not objectively reasonable.
And if those reasonable grounds fail, the strict statutory prohibition lifts entirely.
Exactly. At that point, discretionary bail becomes legally possible for the accused again.
Section 3. Exceptions to the rule.
The critical Section 497, subsection 2, lifelines.
Amr, this is where we find pathways to liberty despite severe criminal charges.
Amr, what if the prosecution's evidence is actually strong against your client, but you have significant mitigating circumstances regarding the accused's personal profile? Section 497, subsection 2 specifies 4 concrete exceptions to the prohibition. In these cases, judges regain their full discretionary power to grant bail. They can grant it even in a severe death penalty case. The first exception applies to persons under 16 years of age. The second statutory exception covers women who are accused of the crime. The third protects any accused person who is genuinely sick or infirm. The fourth is when there are simply insufficient grounds to believe they are guilty. For that medical exception, you need actual, verified medical evidence. Self-serving claims of illness will not convince any judge in court. You need hard proof that continued detention endangers their physical health. These specific categories give defense lawyers a powerful tool against the standard prohibition.
Let us look closer at the exception for women accused of crimes.
Take the landmark Shamim Bibi case from 2015 as the prime example.
It dealt specifically with women who were accused of capital offenses.
The Supreme Court definitively ruled they are entitled to the discretionary benefit.
A judge cannot automatically deny bail just because it is a murder charge.
They must actively factor the accused gender vulnerability into their bail calculation.
The law explicitly recognizes the severe social impacts of pretrial incarceration on women.
It is a vital legal protection against the unique vulnerabilities women face in prison.
It forces the court to balance the severity of the charge with compassion.
Which makes this specific exception incredibly potent during a high-stakes bail hearing.
Section 4, weighing the bail factors, the critical 3-pronged legal test.
This is where the judge evaluates the specific risks of granting freedom.
Once we bypass the prohibitions, securing bail becomes a highly strategic balancing act.
It balances the accused liberty against the state's interest in securing trial attendance.
The court looks at very specific factors that favor granting bail.
Weak evidence, like inconsistent FIRs or lack of corroboration, strongly pushes toward release.
Being a first-time offender or the sole family breadwinner also helps tremendously.
Because they have deep roots in the community and pose a lower flight risk.
But certain factors will weigh very heavily against releasing the accused.
Strong forensic evidence tying them directly to the crime is a major hurdle.
A documented prior criminal record also makes a judge highly reluctant.
And if there is a specific, real risk they will tamper with vulnerable witnesses?
That is a massive red flag that almost certainly blocks the bail application entirely.
It is a highly individualized calculation based strictly on the accused's specific personal profile.
There is one more massive factor that strongly favors granting bail.
And that factor is a severe delay in the trial's conclusion.
The Azhar-Iqbal ruling from 2016 addressed this statutory right directly.
If an accused spends 2 years in pretrial detention without a trial conclusion,
trial courts are explicitly directed to give these applications highly favorable consideration.
The Supreme Court ruled such delay acts as premature punishment before legal conviction.
It favors bail because further detention serves absolutely no legal purpose.
It essentially becomes unconstitutional punishment without a finalized guilty verdict.
This protects innocent people from languishing endlessly while the justice system stalls.
It provides a very powerful legal remedy for systemic judicial delays.
Section 5, the procedural pathway, navigating the courts step by step.
You must understand exactly where to file these complex legal arguments.
Amr, we know the arguments, but we cannot just walk into the Supreme Court immediately.
You must strictly follow the established sequential pathway through the judicial hierarchy.
Jump in the queue and bypassing the normal jurisdictional route is highly dangerous.
Doing so without a very good reason can seriously damage your legal chances.
It will also attract severe adverse comments from the higher appellate judges.
Step 1 is always filing at the trial court level first.
That means applying to either the local magistrate or the sessions court.
If they refuse, you then escalate the matter up to the high court.
You must bring the lower court's documented refusal straight to them.
And if the high court still denies it, you have one final option.
Your final constitutional option is appealing to the Supreme Court of Pakistan.
You build the case sequentially, directly addressing previous judicial refusals at each level.
Amr. Section 6. Bail cancellation pitfalls, the very real risk of losing liberty.
Because securing the release order is actually only half the legal battle.
Winning the bail order is not the end. Keeping it is much harder. The court can literally snatch that liberty right back under Section 497, subsection 5. A bail bond is a strict conditional contract with the state.
You can lose it by actively misusing the granted bail privileges.
That includes actively intimidating prosecution witnesses or physically tampering with trial evidence. Simply absconding or blatantly violating specific court-ordered conditions are guaranteed triggers. Committing another entirely new criminal offense while out on bail will also destroy it. But remember, the legal threshold to actually cancel bail is much higher. It is much higher than the threshold for simply refusing it initially, because you are legally taking away a fundamental liberty that was already judicially granted. If the prosecution wants to cancel based on finding new evidence, that new evidence must be fundamentally strong and entirely new. It must create undeniable reasonable grounds of guilt that did not exist before. It takes a very significant misstep or major evidentiary development to actually cancel bail.
Amir, the Muhammad Aslam case from 2012, brilliantly illustrates this exact legal protection. It protects the accused against frivolous state harassment after bail is granted. The Supreme Court established that cancellation requires strict proof of a specific change. There must be a documented, specific change of circumstances following the release. The state cannot use cancellation applications as an endless tool for mere harassment. They cannot file for cancellation just because the police had a sudden change of heart. They must prove a serious, positive act of abuse by the accused person. For example, presenting documented proof of specific witness intimidation after the release. This ensures the initial bail order carries significant, lasting legal weight. It prevents the prosecution from constantly threatening a person's pretrial freedom without cause. This leaves us with a final, very provocative thought regarding pretrial freedom.
If liberty can be canceled by a single misstep, how secure is it really?
It is a fragile, high-stakes balance between individual freedom and strict criminal procedure.
It makes you critically wonder how much weight that simple bond truly holds.
In the strict eyes of the law, it is a highly conditional temporary privilege.
It is a privilege that defense advocates must fight relentlessly to protect every single day.
That concludes our fast-track explainer navigating Section 497 of the Criminal Procedure Code.
Stay sharp, know the specific procedures, and always be absolutely ready to defend that liberty.